Hi, good morning. I can see a few people starting to join, so I'll just burble on a bit and do a bit of a general chat so that when people join, they know that there's actually a real person here. They could adjust the sound and volume and stuff like that. So hello, it's a bit of a grey morning here where I am. I'm just south of the Humber Bridge. It was raining earlier on, but it appears, yeah, it does appear to have stopped now. But I'm told by the weather forecaster you've had the driest February on record or something like that, which is probably true. Hasn't had a whole lot of rain around here. Okay. What can I talk about? I had a wonderful holiday last month. Some of you may have noticed I was away. I did send out, and we had cover arranged for a couple of weeks, but I went off to see my daughter in Malaysia, and that was very nice. Back to reality now, though, I guess. I know, obviously, you're incredibly busy in general practices. I wouldn't say as always. I think perhaps now is even more so than it ever has been. So this morning's presentation will be as brief and as to the point as I can make it. The intention obviously always to be informative and helpful. I think that's a good way of putting it. But certainly to try and make your the way you deal with information governance issues as straightforward as they can be. I never intend to give you stuff that's going to make your life more difficult. So I try to get find more straightforward ways of doing things. And hopefully, as with all things, once you've done something a couple of times, it becomes more straightforward. We've got the usual lineup of things to talk about this morning. I think the deceased records thing appears to be settling in now, and that's kind of based on the number of questions I get asked, which seems to have settled down. Obviously, I'm more than happy to still keep getting questions from you all about how you do this sort of stuff, even if, and I would say, even if you're comfortable with it and you're fairly sure and happy that you know what you're doing, I'm more than happy just to be there to kind of rubber stamp that and say, yep, that's exactly what you should do. So when you get these requests, if you want to run them past me with what you think and what you're going to plan to do, just to make sure that that all looks fine. Yeah, I'm more than happy to do that. What else have we got? Yeah, the patient access system is obviously now live in some practices. I haven't really heard any feedback from those who have gone live with it. I do know there are a few in our area, so it'll be interesting if anyone has any thoughts on it. It's obviously a fairly complex, although it's a straightforward concept. It's fairly complex to introduce, as all these things are. And in terms of your patients, 95% of them have absolutely no problem with it and will simply accept it and get on with it. You will have a small number who will, I won't say cause problems, but will need to be need a bit of assistance or need to be looked at. I'd be interested to see how many people actually use it. The figures are quite high around usage of the NHS app, but then we were almost forced into that because obviously during COVID, that's how you got your pass, your COVID pass. It had to be recorded on the NHS app. So take up of the NHS app kind of shot up at that time as people all got the COVID app on pass on their app, and I suspect that on the back of that, a lot of people looking at the NHS app saw this option that says, "Oh, it says on here I can view my GP record." Clicked on it and find it didn't go anywhere, and I kind of think that's possibly what some of the prompting for people to make it available. So as we know now, from the point at which you get switched on at a practice, patients will be able to see their own record. And I know from your perspective, you see some of the downsides of it. I suspect if you try and view it from a patient's perspective, there are some upsides to it. There are some good parts about it. And as we're all patients as well, And I suspect most of us have got the NHS app. It would be interesting to see what you think about looking at your own record, and get a feel, I guess, of what patients are going to see. You also got the option in the system, and I'm sure it's still there, to create a dummy patient. So you can create, if you just want to do what I've just described, basically to see what the system does, you can create a dummy patient for your practice, and put some data against them, and then you can all have a look on the NHS app to see what that patient looks like. Okay, it's just gone 9:30. I'll give it another couple of seconds, then we'll start. I'll just kind of go into an introduction, really. There's the last few people are sort of joining. It's up to you whether you have your cameras on. It doesn't bother me. I can't actually see it, so it doesn't really matter to me. But if you could keep your microphones on mute, that would be fantastic. Can I just ask one person just to come on and confirm that they can hear me okay and that they can see my presentation before? Otherwise,
I can hear you, and I can see your front screen, Barry.
Fantastic. Thank you ever so much. Okay, there's always a worry that you start off doing these things and halfway through you realize everyone's left because they couldn't hear you. I'm just talking to no one. Right, so my name is Barry Jackson. I'm Head of Information Governance at N3I, and I'm the Data Protection Officer for the majority of practices in this area, and I provide an information governance service to all of you. So this is going to be an update on a range of general topics, which I'll put on in a moment. What do I have to tell you? Yeah, it's been recorded. And the simple reason it's being recorded is I know that you're incredibly busy. People aren't able to come along who may want to watch it. So we'll put it onto our IG portal in a while. I'm going to ask Amanda if she can just pop the link to the IG portal, which I'm sure you all have already got and know, but just pop it into the chat forum there. So the presentation will be recorded. We'll put it on the forum, and the presentation itself, the actual PowerPoint, if you want to have a read over it again and do it that way. And also there are a couple of links in the presentation which you'll need to go into the presentation itself to pick up on if you don't pick up on them as we go through the discussion. So yeah, so all that will be available online probably about lunchtime today, by the time our wonderful web guy gets it all organized. So let's move on here, shall we? If you can press the right button, would help. There we go. So what we're going to cover this morning very quickly, the patient online system, deceased records. I sound like a broken record on this at times, I know, but as I was saying earlier on in the introduction bit, I think we're all getting our heads around this now, so I think it's more straightforward than it perhaps appears at first. We'll talk about sharing information with the police, particularly appropriate at the moment, and I'm more than happy to have a little bit of a discussion about the tragic case recently with the lady who went missing. And the issues around the police sharing her information. We'll, if we've got time, we'll cover off a little bit of that. We'll talk about the clinical safety service that N3I have got. Freedom of information requests, they occasionally come up, and there's a really important message in there for you all. Mention the data security and protection toolkit. And then our remote access system, which I know particularly some of the GPs use, but obviously is available to anyone. But we'll talk about some of the actual limitations that we've had to put in around that. Okay, so patient online access. We've been talking for this for quite a long time, and it's had a couple of false starts. It was due to go, originally it was due to go live back in April last year, I think. And then there was a really big go live planned for the beginning of November. It didn't happen, and then it was going to be December. Eventually, at the start of February, it has gone live, and it's gone live with essentially the practices who didn't request an opt-out. So if you didn't want your practice to be enabled for the patient online access, you had to write to either EMIS or TPP and ask them to say to them you didn't want to go live. The practices that didn't do that therefore went live at the start of February, and nationally that's over 1,200 practices, I'm told. And that covers 22% of the population. So it was quite a large startup, and I have to say I've been on a couple of calls and I've not heard of any significant issues. I mean, the issues that are inherent in the system are obviously still there, and they're the things that you need to be careful about and manage, but the system itself appears to work, and patients are able to see their information, which is kind of the whole point of it. So and obviously, as we mentioned earlier, what they will see is they will see any information that's put onto their record, essentially from, and for these practices, from the start of February. So once the practice goes live, patients then see any new information that's put onto their record. I haven't seen the plan for how the rest of the practices now go forward, and I suspect at the moment NHS England are kind of managing the settling in period for these practices, and then at some point they will come out, I'm fairly sure, having had extensive consultations with the BMA and various other organisations, they will come out with a plan to roll it out to everyone else, to the practices who said they weren't ready in February. There will be a plan to roll it out to them. As I say, I'm not going to go there yet and even start to think how that will happen, but obviously you will be told, you will be informed, and we'll keep this as a discussion as we go along. Excuse me. So a couple of things that have come up and have been brought up to me locally around this, and I think it reflects some of the national issues as well. Staff names has come up again. We did look at it, and I actually put a fact sheet on the IG portal about this. The basic principle is that staff names have to be available and shown on a patient's record. And kind of, if you turn it the other way, as a patient, you have a right to know not only who's treating you when you go and have a procedure or an appointment or anything like that. You have a right to know who that person is who's treating you, but also you have a right to know who's accessing your record. So from a kind of confidentiality perspective, you've got the right to know who's looking at your record. So if it's an administration member of staff going into your record to upload a letter, for example, you've still got a right to know who's doing that. And so there's a clear duty on us to ensure the staff names are made available. Now, there are occasions where that may be inappropriate, and the fact sheet I've got goes into it and gives a number of examples, which I'm sure we can all kind of visualize, where there's a very clear and an obvious risk to a member of staff from an individual, and in those situations, so there is a potential where you can restrict staff names when it may not be appropriate for the safety and welfare of your staff. And if you get to that point, again, we can have that discussion, but it shouldn't be very frequent, I wouldn't suspect, but it is there if you need to do that. But the basic principle is that the staff names should be available. Coercive relationships, I think from my perspective, when I read through all of this, this is possibly one of the most difficult areas to deal with, where people, obviously, because the NHS app and most people know about it, and it's there to give you access to your data. If you're in a relationship where someone else is going to require you to show them that information, that could become very difficult if you're in situations where perhaps the reason you're going for an appointment is around domestic abuse, for example, as part of that relationship. So there are options in there. There's a thing they talk about called a ghost appointment, where you create an appointment that's visible on the app, which says something fairly straightforward, if you like, but actually behind that on the actual system is the real reason for the appointment, and that's again is all explained on the help pages, which we'll show you in a moment. But I do think that's still a difficult one to resolve, and I actually don't think. I think some of it comes down to society. We can't fix everyone's relationships. And this sort of thing around a coercive partnership would apply to the banking information and essentially to any personal information. So it's not necessarily just on the NHS app. But there are some things that it talks around in the guidance documents. And safeguarding issues have been raised from the very start of the project, and I think there's a lot of guidance on the portal around this, around how you deal with the information that you may want to put on. Information should be checked first before it goes onto the record to be visible. And that those sort of checks that you'd normally do in a subject access request, third-party information the potential for serious harm. Essentially, they've got to be done in real time now as you're going along, and any information that you want to redact from the patient view, you do that as you move along. Okay, there's a go live check sheet which I think is actually really useful, and it's on that link there, which I think Amanda's just going to pop into the chat for us as well. But as I say, later on you'll be able to get this actual presentation and follow that link, and there's a readiness check sheet that has been put up, which I know in the past we often complain about a lack of guidance on certain areas. Deceased records being an absolute classic, no guidance whatsoever from NHS England when they dumped that on general practice. But in terms of this one, there's a huge amount of information, and it's actually been very, very useful. And it's all been done, I think, with assistance from the BMA, and I think they've got stuff on their own website as well. So there's certainly a lot of information and guidance out there, and that check sheet is a fairly good starting point. And the other thing I'd ensure that you do, just picking out one thing from the check sheet actually, that I thought was quite interesting, is make sure you inform all your staff about it. Make sure that everybody's aware of this system, whether you've gone live with it or whether you're potentially going to go live in the future, and have a discussion with them and ensure that they understand the issues, they understand the risks and the benefits as well, because there are benefits to this. I'm not going to overplay them, but I think there are. It's actually ones that will come more in the future. When we think about subject access requests, the majority of subject access requests are from people who want something very specific. They don't often want the whole of their record, although obviously they can get that. They perhaps just want to know about a specific episode of care. Well, it may be that, or it probably will fairly obviously be that that's available for them to see themselves now in the future anyway. So, yeah, but make sure you have that discussion with your staff so that people know that this is coming along. And as I say, and have a look at that dummy patient, or to see who's got access to the app and see what they can see on their record already. Excuse me. Okay. Online access. Management of deceased records. Okay, as I said, I think we've covered this. I was going to make a really bad pun there about how much we've covered it, but I'll skip that one. We have done it an awful lot. And I think, as I said, based on the sort of queries I'm seeing now, I think we've all got the basic hang of it, I suspect. What I would say is, if you've got any queries at all, please come back to me. It's very complicated legislation, although actually we've tried to get it to be more straightforward. So let's just run through where we are now anyway. So since last August, GP practices are required to respond to requests for access to deceased records. So it used to be a role that PCSE did. So you sent the whole of the record, or you printed out the electronic record, you put that with a paper record, stuffed it into the Lloyd George envelope and sent it back to PCSE. Any request for access to a deceased record, you pointed the requesters to PCSE. They don't do that now. You guys, you still send the paper record in the Lloyd George envelope, but obviously you don't print out the record. You're left with what should essentially be the whole record in electronic format. And if you get a request for access to it, you have to work through whether that request is valid or not. So just one point, all of this request to access a deceased person's record is based around the Access to Health Records Act. It's nothing to do with the Data Protection Act. I'm quite amazed how many solicitors don't seem to have a grip on this at all. Although I do suspect a lot of it, they're just reusing a template letter that they have from subject access requests, which is just basically lazy. But a request for a deceased record is nothing to do with the Data Protection Act, which can only apply to living individuals by, that's what it's designed to do. And therefore a request is also not a subject access request, because subject access requests are a very specific process that are set out in the Data Protection Act, and again only apply to living individuals where a person is asking for their own information. So Access to Health Records Act is the act that we're looking at. So you get an individual who passes away at your practice, you mark them deceased on the system, and you send the Lloyd George envelope and the paper record back to PCSE. There's a bit of discussion around this. It wasn't entirely clear what you did with that paper record, and I know many practices were concerned that they're going to have a build-up of a large amount of paper that they couldn't get rid of. Well, PCSE have confirmed that you should still send the Lloyd George envelope and any paper record back to them. Excuse me. That does slightly lead into a bit of a conundrum here, because if you do have a large element of paper as part of a record that's not incorporated into the electronic record, you send that back to PCSE. When you get a request for that person's record, you've only got the electronic bit, but also now you don't necessarily know how much, if any, of the paper element was sent back to PCSE. So there's a bit of it's not a foolproof system, and it's not ideal from any shape or form. But until there is a project in place to replace Lloyd George envelopes and to fully digitize any paper records that are kicking around, which, and I'm sure probably most of you out there are now rolling your eyes and heaving a sigh, that's not going to happen anytime soon. I can pretty much confidently say that. So at the moment, we're stuck into this middle system, but you can send the paper records back at the moment as well, as you previously used to as well. It's not going to just build up in terms of space. So the right of access. So you've done this, you've got a deceased patient, and someone, either an individual or a solicitor, comes along and asks under the Access to Health Records Act if they can have access to that record. So what is the right of access? This is a very, very generalized view of it. It's a little bit more complicated than this, but actually if you've got these principles, that's going to be a pretty good start. So the first category of people who can access the record is someone who's the executor of the will, or if the person has died without making a will, someone will have been appointed to be the administrator of the estate. So either the executor or an administrator, and they will have a document that says that as you are appointed as the executor. It's not someone who is just named in the will, as a practice asked me the other day. It's the person who's the actual executor, and again the administrator of the estate, and they are actually, somewhat surprisingly, I think, have got permission to access the full record. They can have the whole record itself. I'll do a slight caveat to that in a moment. But in general terms, executive administrator, and it's important to remember, and probably just think of your own real life, that's not always going to be an immediate family. So one of the things that we have seen is quite frequently the immediate family, the next of kin, and which is strange enough a term that's not recognised in law, next of kin, or certainly not in the Access to Health records. Next immediate family will come along and say, can I have access to, my late husband's will, medical record or something like that. That's not always going to be the case. Immediate family don't have an automatic right of access. The right of access exists to the executor or the administrator. The next one is slightly unusual. Someone who has a claim on the estate. Now, what I've seen, and I suspect what we are seeing, which is very common, people who change their will near the end of life, that in itself often leads to people who have been potentially excluded from that will and were expecting to be beneficiaries to make a claim to say that the will was changed near the end of someone's life, either by someone putting pressure on them or because they weren't of mental capacity and all those sorts of other questions. And that, and I think it's quite a common thing. It's turning out, based on the sort of queries I get from practices, to be more common than I actually thought, but it is potentially a common thing. And in that situation, a person may say, I've got a claim on this estate because actually the will isn't valid because it was changed at the last minute to give all their money to the donkey sanctuary or whatever. And therefore that can be quite a common claim that someone makes. Now, in that situation, they're allowed to have only relevant information be provided. So if the claim relates to the mental capacity of the person, you could look at the record and say, either, yes, there is something here. And we've had a case just the other day where actually the person had changed their will and they must have been aware of a potential challenge. They had actually asked the nurse at I think it was at a hospice to write into the record that the person had full capacity and they knew what they were doing. That's probably unusual. You're not going to get as clear as that. What you'll often get is the other view that someone said this person lacks mental capacity to a certain point, and therefore that's really relevant to a claim on the against the estate. But as I say, at that point, someone asking for a claim, they need to tell you exactly what their claim is, what the nature of it is, and then also they need to say to you what information they're they're expecting to get, what it is they want to see, if you like, from the medical record, and they're only entitled to get relevant information to their claim. Okay, that's really quite important. So the other one that kind of overrides the first bit, so I say, executors and administrators can have full access to the record. There's a concept in there around what the patient would have wished, and this is very difficult. Often patients will have actually, sometimes it isn't, sometimes really easy, because the patient will have made it clear that they either do want something to be made available, or more likely that they don't want either certain individuals to see their record when they've passed away, or for essentially anyone to see a certain episode of care that's in their record. Now, and you're required to respect that wish. It's slightly difficult. It can be open to challenge, but my view is, and certainly when you read some of the guidance from BMA and so on, and the NHS England, is that the wishes of the patient should be respected. It isn't quite, I'm not going to say it in every situation. You can't write scenarios like this for every single situation, and there are some where clearly it's not appropriate. But you should protect the wish of the patient, and also, and this is a really important point, you should protect their confidentiality, because although they're now deceased and the law has changed, the duty of confidentiality that you have towards them is still in place. And that's a really important point that the BMA make around their guidance. They say, just because a person is deceased, if you wouldn't give a person's record, I don't know, say to his eldest son who walks in a practice one day and says, "Can I see my elderly father's record?" You say no. Okay, the next week the elderly father has died, the son comes in and says, "Can I see the record now?" You still got a duty of confidentiality, so you would still say no purely on a confidentiality basis, because there's no, why would you do that? You still have a duty of confidentiality towards that record. Now, this becomes important when you're into situations where there may be information in that record that you would think deserves to be treated very confidentially. That's not the right word, in a very confidential way. And I'm sure we can think of situations where there may be something in a record. We have records that go back a long way now. Our electronic records will go back in many cases to the individual's sort of start of life, and there can be episodes of care in that record that it'd be fairly obvious that the patient wouldn't necessarily want their current immediate family or their executor of the will or whatever to have access to. So there is a concept here that the duty of confidentiality still kind of covers all of this in the same way as it covers the existing patients who are covered by the Data Protection Act, and the duty of confidentiality sits on top of that. Your deceased patients are covered by Access to Health Records Act, but the duty of confidentiality still applies as well. So it's an overlapping concept, and it isn't, duty of confidentiality is a very difficult one to write down and to be clear about, but there are and there will be situations where it's appropriate to maintain that duty of confidentiality by not giving out information at certain times. And certainly the wishes of the patient should absolutely be respected wherever possible. Not, as I said, but not in every situation, which is what makes this kind of difficult. But I do recall a case that a colleague of mine used to tell me about that happened up in Willoughby not so long ago, a couple of years ago, when there was it was a fraudulent insurance claim. And this is the sort of thing you kind of slightly have to be aware of, where the patient had been diagnosed, took out a large insurance claim, passed away, and one of the last entries in their record, they'd made sure that they'd said no information from my record was to be given to anyone at all. So when the wife made a claim on this large insurance policy that had only recently been taken out, the insurance company were rather skeptical of it and thought there may be an element of fraud, and that had to go then actually to a court. But they were able to overturn the wishes of the patient because there was a clear duty of fraud, or the clear case of fraud actually involved. So there are always going to be slight nuances around, yes, we can say it's always this, except for the couple of times when it's going to be something different. But I hope that gives you a kind of a flavour of this and where we go with it. And I think that's been reflected in the sort of questions you've had so far. I would say we have recently had one case where the practice and the doctor were very clear that they had a patient who essentially was estranged from her family. Her family lived down in Kent. She was local up here. She tragically got diagnosed with cancer, and very close relationship with the doctor, went all the way through, but eventually passed away. The lady's mother then appeared on the scene and requested access to all her records, wanted to know what had happened and how it had been done. And the doctor was absolutely clear that from the discussions she'd had with the patient and which had been recorded in the patient's record, that she didn't want any of her family to have access to her record because she'd been estranged from them in her life and she didn't want them to have access after she passed away. And she was very clear about that. And so as a result, when the request came in for access to the record, we said no based on the wishes of the patient. The practice refused the request. The requester, who was the patient's mother, went through the full complaints procedure to NHS England, to the GMC around the doctor had basically every avenue she could possibly do. But we were very clear, and the doctor was very clear that they were going to refuse access and wouldn't permit it based on the wishes of the patient, and that was upheld at about 3 different appeals that the individual had. The decision to refuse access was upheld, and that was the first one we've seen that had gone all the way through all the different process. So you can, you can stand your ground, which this doctor did very, very eloquently, and make your case. And it will be the right thing, and that upholding that duty to your patients. Yeah. Someone's put a hand up. Michelle, do you want to ask someone to ask a question?
Yeah, just so we've got that on one of our records, and we have got advice from you on it, and the patient didn't want to share information, so we refused to share information, and it was to a solicitor. And then we've got went to another solicitor, and so they're claiming negligence against the practice. So is that different then? Do we have to give them information if they're saying that would be negligent? So if a patient said, I don't want to share my records, but then a family member claims or makes a claim and saying that somebody somewhere has caused negligence, can they then go down that road and have access?
No, I don't. Yeah, I see where you're coming from. But no, the case we had, it was absolutely clear that the patient had clearly made her wishes known, that she didn't want her family to have access to her record, and we just simply said that there was an appeal. There was a pre-hearing where we were supposed to put forward the record for the solicitors, and we just kept refusing and just said absolutely not. The patient was absolutely clear, due to confidentiality, given that it was a clearly expressed wish that no one had access to, and that was upheld at every. I think there were about 4 different types of appeal in different organisations, that NHS England, certainly GMC, and various others, and that was upheld. So I think you stick by your guns on that one.
We haven't sent anything to them. We've sent it to our obviously defence union, because if there is any negligence, they can.
Right.
So we haven't sent it to any of them.
That's fine. I mean, if you stick with that, I mean, you physically got the record. You can't be forced by anyone to give up that record other than a court. There's only a court of law, and the individual can eventually take a case to a court, and a judge can say, can make a final decision. And that can go anyway. I've just, it's not always clear, but you would hope that the judge would find in your case, and at that point, that's it. But if he did find against you and said, no, you must release the record, then a judge in a court is the only person who can require you to actually release that record. No one else can. And if you're content on your position that is, that it's you're respecting the confidentiality of the patient, then that's it. You stay with that position until probably at the end of a final process, a judge may potentially say you have to give it up. But other than that, no, you don't.
Right, lovely, thank you.
Okay. Right. Yeah, I mean, that's really useful to see some of these real-time examples. And I would say to everyone out there, as I was saying earlier, that if you do all these types of things, and as Michelle there, you're confident in your own processes and procedures, but if you want, just to have it double checked or just to have my view on it, more than happy if you send it to me, I'll give you my view, probably have a chat about it and so on. But it will also it'll help me a lot because it'll build up that knowledge, that that experience around doing it, because I appreciate that these are probably fairly not unusual. I suspect you get fewer of these than you get subject access requests, and of course, and they are very different as well. But you're probably going to start seeing not more of them, but obviously you're going to start seeing them because you're required now to process them. But it would be useful to kind of build up that knowledge base in the same way as we built it up around Data Protection Act and subject access requests. Even though you probably get fewer of them, you're not going to be dealing with them all the time. So it's useful to be able to kind of see what other people have done and get that experience and build that knowledge base. And obviously I'll do that without not naming people and so on. We could put up, I'm trying to create some sort of FAQ type thing. So what do you do in this situation? What do you do in this situation? With an example of, well, this a practice, an unnamed practice, we're able to do this, 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 and this. And I think that'll be helpful to all of us if we can share that sort of learning. Okay, moving on, sharing information with the police. Some of you know, because I've probably said this before, I'm a former police officer, so this is said with a slight, well, no, I'm trying to be absolutely neutral here, and I'm not, and there's no concept really of being for the police or against the police. You don't do that. The police are an agency that we all work with because they have a clear job to do, and there are times when they will come to a practice, and you'll deal with them appropriately as the law and as guidance requires. So the police have a legal duty to investigate crime. That gives them their legal basis to come to you and say, can I have access to this record? Can I have some information about this patient, etc.? That gives them the legal basis to ask that question in the first place, because they are legally investigating crime. That's their job. And what they have to do when they come to you and ask for information, they have to make the case. So there's a document which I'll put on our web portal, which is the Homicide Police have designed this form which they have to submit. So they'll submit this form to you, and it's got all these different boxes and all that sort of stuff. But essentially, what the law requires, what the Data Protection Act requires, is that they make the case. So they kind of have to convince you. It's not enough for them just to send you the form and say, can I have access to Mr. Smith's record? They have to say why, and not any great detail. They're not going to come and give you the whole case file and the whole investigation around Mr. Smith, but they have to be able to explain why they feel it's relevant that they need to have access to specific information from Mr. Smith's case. Okay, and that will usually be just a conversation with probably between the police officer and yourselves as practice managers. But it is up to you how much, how far you want to take that, and you need to be, I suppose, you need to be satisfied in your own mind that there is a clear requirement for the police to do their investigation, to be able to do the work they're required to do, and therefore they need this information. Consent often comes in. You don't have to give or have to get the person's consent. Now, there are two reasons for that. First of all, it may be quite difficult to get consent, and the police investigations are often fairly time limited. So it may not be, you may not be able to track the person down and say, is it okay to do this? And also, and I'm sure you can visualize, there are quite a few cases where the police might say to you, and actually on this form that you get, there's a box there to say, do you want the person to know that the request has been made, if you like? Do you want to ask for consent? And if the police say, we'd rather you didn't, because actually this person doesn't really know about the investigation at the moment, again, as long as they make the case, that's fine. So the the default position generally is that we should inform people when their information is being used in a certain way, but we don't have to. And certainly if the police say to you, well, this is a background check, the person doesn't know yet, we just need to have this straight away and we don't know where he is, then it is okay to go ahead and release information without the patient's consent. Right. Okay, before I go on to the other agencies, just I know it's very relevant, so let's just think about the tragic case recently with the lady who appears to have fallen into the river, and the police released some information which was fairly personal medical information, I think, which I presume they must have got from the practice, and there's a lot of discussion around were they right to do so. I'm not going to give a kind of personal view on that because I'm going to follow it very closely because, as I say, as a former police officer, I find it very interesting. And also as someone who knows a little bit more now about data protection, I think in the future, because what they said is that the government, all the way up to the Home Secretary, have said, we're going to be interested to find out what your justification for this is. I think we'll sit back, let the police do their work, and then at some time, we're going to hear their justification. I can see how they could potentially justify it. And a lot of these, as with many of the things we've talked about today already, they're not black and white issues. Two different people may well take a different view on the same set of facts. And it was clearly the case that in this situation, the officers in charge of the investigation felt that it was appropriate to release that information. I presume they discussed it with they'd certainly discussed it with the family. Clearly the individual wasn't available to give consent, so there's a good example of just that very fact, the fact that they were looking for a person who's gone missing by its by the nature of the incident means that they could never have got consent. Therefore, in that case, obviously they were given access to information without consent. I'm not clear exactly whether they would have gone to the practice or whether the information actually probably came from the family as we understand it. But it's an interesting case, and like I say, I'm going to keep following it and see what comes out of it. But it does raise some questions, shall we say. Okay, the concept of the police having a legal duty to investigate crime. Strangely enough, there are an awful lot of other organisations that have a legal duty to investigate things, not necessarily say crimes, but have an investigative duty on them. And that's normally the question. If you get an organisation come to you saying, can we have access to this information because we're doing this? The first question to ask is what they're doing a statutory thing? Are they established in law to do that? And there are lots of organisations, probably way more than you'd imagine, that do have this legal authority to investigate. So CQC, the GMC and the NMC, I'm sure you'd be aware of that one, coroners, the ombudsman, and certain NHS organisations. And I've used the one here about the Learning Disability Mortality Review, just because it's actually come up recently a couple of times. So NECS, what are they? The North of England Commissioning Support Unit. They're an NHS organisation, and they've been commissioned sort of by NHS England nationally to do this piece of work. So because there's a formal NHS England are required to do this investigation or this this piece of work, and they've got a statutory instrument that provides their right of access to do it. They've then kind of sub-commissioned, if you like, NECS as an NHS organisation to actually do the work itself, and that in itself gives them the right to be able to come to you where they have individuals who've died who have a learning disability. And some of you will have seen these, I'm sure, and they're pretty good. They have all the legal bit written out, and they'll come to you whenever they someone with a learning disability passes away. They do this review, and you'll be asked to give them information, and they have that. There's a full legal basis behind that, which they set out on their request quite well. As I say, other agencies and organisations as well. So as long as they have a statutory right to do their investigation, then that's fine. And again, going back to the bit at the top, what they need to do is to make the case to you. It's not a case that they can simply, here you go, we've got the legal right to do this. You need to give us this information. They need to explain why, because it wouldn't just be, they wouldn't get the information on by default for every patient. They need to explain why they need Mr. Smith's information specifically and which bit of Mr. Smith's information they want. You don't just necessarily get the full record unless that happens to be part of the investigation that they're doing. And again, they need to make the case for you. If the CQC said, well, we need to see the whole record, the whole of Mr. Smith's record because of the nature of the investigation, then that's fine. But if it's just an investigation into a specific episode of care, then they'd only get that bit because that's the only relevant bit. Okay, let's move on. I just wanted to highlight here that we have a clinical safety service. So N3I are required by our contract to provide a clinical safety service to you, to all practices. We contract with two very experienced clinicians who have also fully qualified as CSOs, clinical safety officers. So they're qualified and registered clinicians, and then they do some additional training with NHS Digital to become clinical safety officers. And we have two of those in place. And they do essentially two elements to their work. The first one is they check all the new systems that come in, new ways of working, similar concept to what the stuff that I do around a data protection impact assessment. So they will do a clinical safety assessment of a new process, a new system, whatever that is. And that involves an awful lot of work, and there are specific standards that they've been trained and they assess against. So that's one part of their work. The other bit is the day-to-day reviewing of service desk calls, and they review every service desk call that gets logged. In fact, on our login system, calls can be marked as clinical safety incidents, but the two staff actually go through every call and check it, and then they work with our team, certainly our digital optimization team, and others, sometimes the technical team, to ensure that if the incident that's been reported is deemed to be of a clinical safety incident, then the CSOs will ensure that it's monitored and given, I won't say a priority, but they certainly keep pushing it and ensure that it gets fixed as soon as possible. And they monitor all of the calls that get put through as CSO clinical safety incidents, and ensure that they are done and tied off properly. And the most common ones they deal with are ones around duplicate NHS numbers, duplicate calls, duplicate records, and that type of thing. So you may come across them, you may sort of speak to them, but they are there, they're in place. And if you want to specifically speak to them, if you think there's something specific that you'd like to deal with them, the easiest way is just to put a service desk call in saying about this, and I'd like our clinical safety people to have a look at it or to give you a call about it or whatever. So that they are there to provide that service. Yeah, contact them by the service desk. Freedom of information requests. Okay, we'll skip through this fairly quickly because I know you don't get very many of them, but it's important to remember, irrespective of what you think you are, for this specific piece of legislation, that's the Freedom of Information Act, you are classed, a GP practice is classed as a public body. You can argue to the cows come home whether you are or not, but the Act itself specifically says you are, therefore you are. Where you get a request that comes in around that mentions the freedom of information, the key thing is you've got to respond to them. The chances are, as I put here, often from journalists, special interest groups, they will focus on you if you don't reply, because they'll think, okay, why, if they ask you a question, they ask 100 practices, 80 practices ask and give them some banal answer, 20 don't, they're going to go for those 20 and say, okay, why didn't you answer that question? There's obviously something wrong here. What are you doing? So make sure you respond to them. A couple of things, if you're into identifying things such as very small numbers, anything that identifies a patient cohort of less than 5, that can be exempt. And then we had one recently around asking all practices how many of a very unusual type of condition, how many patients did they have, and in most cases that fell under the number under 5 for a practice, therefore it was exempt. And what I would say is, please ask me. I've done a lot of work with freedom of information back when I used to do PCT days, when the whole Act first came in, and we had to start getting used to it. So I've got a lot of experience of it, and obviously I've got colleagues who have as well. And often what we find is that if one practice has received a question, others may well have had it as well. So we can share kind of our perspective on it. So if you get a recruitment information request, key thing is you must respond to them, and please just ask for some guidance at that time. Data Security and Protection Toolkit hasn't gone away. It's not due at the end of March as it usually is. It's due at the end of June. So you may recall that the dates for it were all messed around with COVID happening, and it got changed and swapped around. It ended up being set as the end of June, and they've decided they're going to leave it there. So it's not going to revert to the end of March. The assessment date that is due will be at the end of June. Everybody has to complete it, and as you probably remember from previous years, there's some technical queries that are in there, and we'll provide you that technical data probably in early June, so that you can go in and put that stuff in and then do the other stuff yourselves. Okay, I think this is the last thing I've got, remote access. So you'd be aware of the VPN system we have, whereby if you're working from home, for example, on your home Wi-Fi, you can connect through our VPN, which will obviously allows you to connect to our systems, and you can get that to work through any sort of public Wi-Fi system. VPN essentially creates a secure tunnel between your computer and our network systems, and it works essentially over the internet. So it's a very secure system. However, it has limitations. It used to be available worldwide, and the Information Commission's Office has confirmed that it's legal to work in other countries working over a VPN, because you're not transferring data. What you've got to be very careful of getting into not transferring data outside England, obviously specifically not personal data and NHS data. That must not be transferred outside the UK or outside England. But you can, if you're working overseas, you can access your system, call up the VPN and view data, because that isn't transferring data. You're just viewing it, but you're viewing it as it is back in the UK. And it'll work for clinical systems. For example, you could view System 1 if you're overseas, and because you're viewing it, the data on System 1 stays in the UK. You view it across the VPN, and that's legal. But what's not legal is for you to then download data to your local computer, because that would be transferring the data. Okay, but it's legal to view it. It used to be available globally. So our VPN system, when we had it 3 or 4 years ago at first, essentially would work from anywhere in the world. However, as we all know, there's been a pretty horrendous war in Ukraine, and some of the cyber attacks that we're seeing have become way more sophisticated, and appear to be emanating from a very specific area of the world. So we followed government national advice. So CESG and these parts of government that are responsible for what we call the national critical infrastructure, which the NHS systems are part of that. They've given us some clear advice on the fact that we've got to restrict our VPN. So it is now only available across North America and most of Western Europe. The key thing there is, I'm afraid many GPs used to use it when they went to often had extended holidays in India and Pakistan and these sorts of areas across Asia. It was quite common for individuals to go over for a number of months, and they would be able to access our systems still and keep up to date and do a bit of work. That's not available now. It's only available across most of Western Europe and North America. But there's a fact sheet on this as well. I can say it is okay to work from these areas, in terms of, say, North America and Western Europe, if you need to, and you can do that. So you can, if you want to ask me about that one. And that's it. Are there any questions on that, guys? Let me just see if I can stop sharing and go back to this.
There was a question quite early in the chat, Barry, from Caroline, about if an insurance company is requesting details regarding a claim on life insurance, how do we process that? And do we need any right of access details?
Yeah, you do. So if the right of access has to come from the individual, so if the insurance company are challenging something, it'll be because there's an individual kind of behind that challenge, if you like, in the same way as an individual will go to a solicitor and ask them to act on their behalf. If it's an insurance company, there'll be someone who's asking to act on their behalf. And I'm thinking of the actual, I don't know if it's relevant, the little scenario I gave where there was a suspicion of fraud and it was the insurance company who were refusing essentially to pay out. And that situation, that's gone beyond basically the access rights to that's into a court. So that would be and a court would be saying to the insurance company, yes, you can have this access. That's gone beyond basic someone asking for a right of access under the Access to Health Records Act. That's probably a criminal inquiry into fraud, and there'll be someone other than the insurance company who'd actually be making that inquiry. Probably the police, in fact, would be involved at that stage. But not just you don't just give an insurance company access because they're asking, because they think there's something going on. Does that make sense? I'm not sure who asked the question, but if that kind of makes sense, hopefully. Okay, so as I said before, the recording of this will be available along with the actual presentation itself on our web portal. And I'll ask you to keep looking at that. As I mentioned, I'm going to set up an FAQ, and I keep trying to put new stuff on there on the blogs and so on. And we've done a bit of a revamp of it recently and got rid of some of the old stuff. So hopefully it's still useful. If there's anything specific that anyone would like to ask me about, yeah, please do that. Hang on, I just saw something pop up there. Where can I have a look at this? Okay, so this is Caroline. Let me have a quick read through this presentation. So you assume that the insurance company refusing to pay out, and so asking for details of the lifelong illnesses, etc. Okay, the insurance company, presumably at this point, are suspecting that there's fraud. They need to be going to someone who has, I mentioned, has that legal basis to investigate. So I presume if they think there's fraud, they need to report to the police, and then the police will investigate that, and they have a right of access to be able to, come to you and say, we're investigating fraud here. Can can we have access to the information? So that's the route for that. The insurance company on their own don't have a legal basis to access the record. If they suspect fraud, they need to report that to the police, and the police will investigate potential fraud. Does that make sense, Caroline? If you want to, Caroline, if you want to ring me or get in touch outside the meeting, I'm more than happy to have a chat about that, if that would be helpful. Having just said that, I'm straight into another meeting this morning. But if you want to drop me an email, and I'll pick up, and probably this afternoon sometime will be a good time for a chat if you want to do that. Okay. Thank you all very much this morning for coming along, listening. As I said, we'll get the stuff up online fairly soon, and keep checking the IG portal. And I'll have a nice day. Thank you all very much. Cheers.
Thank you. Same to you.
Thank you.
Thanks.
Bye.
Yeah.
Thank you.